Welcome, everybody, to another episode of the Main Street Business Podcast with my illustrious partner here, Matt Sorensen, Mark Kohler here. We are on pins and needles waiting for the Depp Heard jury verdict. Is that what we're covering today?
Yeah, we'll be covering the trial. As you know, there was testimony today from...
No, there's not testimony. It's in the jury. It's to the jury. Have you not been...
I don't know. What was it? Kate Moss gave some testimony, or who was the model that gave testimony? I don't know. This is getting crazy.
You're a little behind the game. It went to the jury a couple days ago. So
okay, what do I know?
Are you not watching the news? Do you not watch TMZ?
No, I'm too busy being a real lawyer.
Oh, so now you're calling Johnny Depp's lawyers not real lawyers? Okay.
Okay. Well, what do I know?
Are you Team Depp or Team Heard? You haven't.
I don't know. I'm Team Justice. I haven't followed it enough to know what team I'm even on. I just know I like Pirates of the Caribbean.
There you go. Caribbean, tomato. I don't know.
Whatever.
Okay.
Captain John.
Welcome, everybody, to part 2 of the estate planning series. This is good stuff. Today, we're talking about decisions that you're going to have to make. We're going to keep it light and fun and interesting, as if you didn't already notice that. We're going to try to, give you a spoonful of sugar as this medicine goes down. So,
yeah. And we will try to make jokes. We can't promise they'll be funny, but we will try. And this is kind of where the rubber meets the road, though. I think this is where a lot of people are like, yeah, guys, I got it. I'm going to die. I need an estate plan. Duh. It's kind of like people are like, I have life insurance and I pay for that every month. And why did I buy that? Because I'm going to die. Do I have an estate plan that says what happens to all this when I die? No. And so we all know we need to do this. But the problem is people get stuck. We're trying to give some context so you don't get stuck and give you a process with a real attorney to help you figure it all out, pull it together. It is not that hard. So don't get hung up on this. Hopefully this episode will illustrate how you can work through these issues and some things you should be thinking about that can be very beneficial to you in planning your estate. And as we like to say in the first episode, planning your legacy, really, because it's more about just not who gets what, but it's about the things you want to happen with your money and how you want your kids involved or whoever your heirs are, nonprofits, whatever you're trying to, do when you pass.
Yeah. And the short version of what Matt just said is quit procrastinating, and we're going to try to get you through those feelings that you're having right now during this podcast. So, yeah. And
Mark, I billed by the hour for a decade. There's no such thing as the short version.
Fair enough. I'm not going to follow that up, but you did set yourself up for a very common comment that is totally inappropriate for the show. So I'm just gonna let that fly into the ether. I'm just, because I take the high road, Matt. I want you to know that.
Everybody can rhetorically ask that question.
My mind is completely focused on estate planning right now. I wouldn't have thought to say anything when you said that statement you just said. Okay, now let's start with this point. People, an estate plan, 99.9% of the time, is going to be based on a revocable living trust. That's the backbone of this entire estate plan. It's the Bible of how your estate plan is going to be carried out in your estate and your assets. And there's a key word that I just said in there, revocable. So the first thing I want all of you to know, and this is why if you're on our website right now, on the page for estate planning, and you're watching this a little frustrated and like, I hate doing this, or I'm stalling again, I'm procrastinating, I don't want to do this. Let me just say this. It's revocable. Freaking throw a dart at the wall. Let's get this darn thing done. Now you can go bungee jumping and skydiving this weekend. And we got a plan. Now, you wake up a month from now on a cruise ship with a margarita and you want to cut someone out, give us a call. You can amend it. It's revocable. But let's get something in writing, or the state's going to carry out their plan, not your plan.
Yeah. Usually the boat, drinking a margarita, that's not the time you make changes to your estate plan. But the family reunion where, someone ticks you off, that one, we get that one. That one's a little more common. Or maybe the holidays, people come back from holidays. estate plan amendments just seem to rise during that time of year. I don't know what it is. I don't
Yeah.
know what it is.
I know there's a correlation. I want to like figure out a spreadsheet that correlates the number of amendments to an estate plan versus on the number of days you spend at your mother-in-law's with all the family. And yeah, there's a
it's science, really. It's scientific. Okay, well, let me.
It's amendable. It's amendable. That's point number
You
one.
can change this, and I think a lot of people are like thinking of, I need to find the perfect person to be my trustee or the guardian for my kids. That doesn't exist. Everybody struggles with that. Just pick the best person available. Okay. You know, like how you were like in elementary school, how you'd pick teams and you'd be like, okay, I don't get my first pick.
Yep.
There's 5 kids over there that I have to pick on my kickball team. I'm getting one of those 5. Okay. You're getting the best one available. Okay. LeBron James or what else, you know.
Yeah, you got picked. You're done.
You know, maybe that's not his game, kickball.
Yeah. Just take smalls.
What's this? Give me a soccer player. I can't even. Lionel Messi. He's not over there. You know, he's not standing there for you. All right.
I went to Sandlot. You know, I was going to say take smalls. Okay, now let's talk about the first thing in your estate plan. There's some key people. Now let me just lay out the key people, and then we'll go and explain who they are. The first one, I don't know if there's any particular order. I'm going to go first. Is if you have minor children, you're going to choose a guardian for your children. Who's going to raise the kids? We'll come back to that. Number 2, you're going to choose an executor. The executor is what I like to call, and I know I may offend someone, the party planner. They're going to plan the funeral. They're going to be the ones to kind of go through your house, do the eulogy, figure out the funeral, the color of the flowers, the coffin, whatever. They're kind of putting together the details. We'll talk about who that might best be. And number 3, you're going to have a trustee. The trustee is going to run the trust, really be the numbers person. And we'll talk about, do they have to be local? Can it be 3 people, 1 person? And what would their role be? So you've got guardian, executor, trustee. In my most recent article, I even talk about a guardian for your pets. You may choose someone to take care of your pets, and we're going to talk about money set aside for them. But before we think about provisions, let's just talk about appointing people. And then that's really, once you get that going, really you feel like you've left the station. You're off to the races.
Yeah. So I think for those of you with minor children, the one you may struggle with the most, and probably the most important decision, is going to be guardian. You know, who is going to raise your kids if you pass before they're, adults? And if you've got minor kids, this is definitely part of your estate plan. It's actually part of your will. And so the first thing I want to say is the guardian, you should think about who would be best, raising my kids. It may not be your parents. I think a lot of people, their first inclination is grandma and grandpa, one of the grandparents. And that might be the right situation. Everybody's a little unique, but I want you to also think, was grandma and grandpa ready for that? Are they a little past that phase of life?
You may think they love your grandkids. They love your grandkids to a point, and then they hand them off back to you. They don't want them to stay the night.
They're also maybe in a different stage of life, but maybe you have a sibling with some kids of similar age or close friends or other. I want you to think, just don't go automatically to grandma and grandpa. That'd be my first consideration.
Number 2, I would say don't appoint a couple. Some people go, I'm going to appoint my sister and brother-in-law, or my brother and sister-in-law, or a couple. What happens if they get divorced? Where do the kids really go? Don't think of a couple, think of a person. Now, usually when it comes to rearing children and nurturing, it's going to be a female, and that female, that woman might also be a trustee, an executor. They can be the same person who can serve in all 3 roles. We'll come to that. But you may be choosing someone to raise the kids that's great with your kids. They live in the same area. Your kids don't have to change schools. They may be in, we see movies all the time where kids are uprooted and go across the country, and then there's a drama, a whole drama. There's movies. How many movies? But you might want to be thinking of who's the best person that may not even be in the family. It could be, this is where the godfather comes into play. The godfather may not be, or the godmother that's going to raise your children, have to be family. so, I mean, I could just keep going on here, but thoughts on couples and female and family and local. I mean, it's all kind of part of the same equation.
Yeah. And everybody's different. It might not be female. It might be, and your kids might be older or teenagers. They might be younger. You know, your parents might be younger. And so they're younger grandparents. Like you might have close friends that might be the right fit, as opposed to family. I mean, it's everybody's a little different, but one thing is think about the best situation for your children to be raised in, the values you want, the people that will instill those values on your kids the best, that will love them. And think about that. Remember too, many times the person who's guardian is different than the person who's the trustee that's going to control the money.
Yes.
Which we'll talk about here separately.
Yeah. On that note, you kind of don't want the person that gets the cookies in charge of opening up the cookie jar. So the trustee is the one that takes the lid off and distributes money. The guardian's the one receiving the money. And they're going to go, oh, you know what?
The cookies.
they're eating the cookies. They're like, the kids, they really need a trip to Hawaii. Oh, there's the trust. I'm going to take the lid off and let's all go to Hawaii. The kids need it. No one's there to control that. They can. So you got to be careful giving the guardian the checkbook, because they could justify a lot of expenses that a trustee might be like, you're doing a good job as a guardian, but I don't think you need to go to Hawaii with the kids.
Yep. And sometimes that is the right person. That's a gift. Sometimes the person with it could be the same person. Or sometimes I get people who are like, well, I don't really have anyone else. This is the best person I trust in both instances of money. Okay. Sometimes you're going to just fall into that. But if you're like, you know, I got someone that's really great with the money, that would know my stuff, that would carry out all the provisions, and I got someone to be great for raising my kids, and it's separate people. Awesome. You're like, you got the best of both worlds. Yeah. So again, I just want to say everybody's a little different. But let's talk about trustee next, because I think.
Okay. Hold on. I want to say one more thing about guardian, because I was looking at notes here. If I may, is when you're appointing a guardian, you're going to need to also think about a backup. So if you do appoint someone older, like your mom, make sure you have a younger person, and think of the current age of your children. If they're 5 and 6 years old, you're talking about your mom raising them for 12 more years. And again, thinking of your mother's health and her life and what she wants to still do in her golden years, you got to be sensitive to that. Also, in your trust, you can set aside some money for your guardian in it and say, hey, whoever I'm appointing as a guardian of my children, I'll have them I want the trustee to give them 50 grand right out of the gate. They can buy a bigger car, buy a bigger house. Maybe it's 100 grand. I don't know. How many kids do you have? And then you can say, and I want the guardian to get $1,000 per month adjusted for inflation per child while they're under age 18. Once those 3 kids turn 18, guardian's job's done, money's cut off. So now, one thing in all this is the attorney that you work with at our office is going to help you with your statement. They're going to walk through all this. They're going to talk through all of this. What we're hoping to do is just give you some ideas to get your juices flowing. So,
love it. Okay. Trustee. Let's hit that. This is the big one.
Money person.
This is the person who controls the lid on the cookie jar, I guess.
That was a good analogy. You didn't like that?
I mean, I guess.
Okay, give me another one right now. Okay. Come on, give me another one.
We can roll with cookie jar. I just think of like the Cookie Monster busted into the cookie jar. Okay. The trustee. Now, this is the person that's going to run the trust. They are going to have a ton of power. You are putting them in charge to run everything. They do not have to go to court. All right. The nice thing about the trustee is the terms you put in the trust, the trustee is going to carry out, and they're stuck. They have to do what you say in the trust. Now, that being said, a lot of people are not going to be involved. So this person you must have trust in, hence the word trustee. And they're going to be carrying, like we said, everything out.
Now, on this note, they don't. I like the guardian. Like, I love what Matt said is choose a guardian that's in the best interest of your children. Maybe not your extended family and what they want. What's best for your child? Here, it's like, what's best for your money? They may be terrible with kids, but they're good with money. They're trustworthy. They're, Scrooge or whatever. But so you want someone that's going to treat that money wisely, carefully, smartly, and they could be local. They may not be local. You can also appoint 3 trustees. I don't want two because they'll get deadlocked, but you might appoint a financial advisor, a brother and a sister. You might appoint a mom, a dad, and a CPA. You might have this kind of a third party in the mix to be like a tiebreaker on votes or whatever. Where a lot of times I've been appointed, my attorneys in my office, accountants are appointed as a part of a 3-person trustee group. But they don't have to also be local. They could actually be foreign. I think that's a big hurdle. When someone trying to run your US based business or money from another country, I wouldn't recommend that. But it can, but that's possible. But I don't know if that's really functional.
Yeah, foreign trustees, we've just seen some issues with those, but it's again possible. It's just logistically sometimes it gets hard. Every once in a while, someone needs to show up at a bank for certain things, or or have the right ID, or they got to get verified, and so you got to be just that as a consideration where I've seen some issues. But okay, on trustee, one other thing to keep in mind is you want someone that can figure your stuff out. If you're a business owner with a lot going on, you've got bought a lot of real estate, you've got a business that needs to operate, you need to think of the right person that can figure that out and that can dial that in. And you need to leave some helpful information. Wouldn't it be nice if you had a trifecta diagram done when you did your estate plan that outlines all your stuff and how it's owned, how it's coordinated with your trust?
Yeah.
Someone coming in after you pass could be like, oh, I see what they have here. Or I could at least take it to someone to help me figure it out. So, so think of someone that can help with that. If you're a business owner, that's certainly helpful to have someone that could understand that. Now, many times you're going to be trustee during your life. Usually when we set this up, you're trustee now. And if you got a spouse, your spouse is a co-trustee with you. When the first of you passes away, the other one is their surviving trustee. But when the second to die goes, or maybe you're single, what's going to happen is we're talking about your successor trustee that comes into play after you've passed away.
I'm glad you pointed that out. We probably should have led with that. Moving along here, because we want to get to some unique provisions, I'm going to bring up executor. The executor, again, is another unique person that could be the same in all. The same person could serve in all these, but this would probably be a person that's local. They're going to be the one dealing with the funeral home, the wake, the viewing, the funeral, the maybe going through your house. They're basically going to be the local boots on the ground. And they, again, could be not great with money. They may not be great with kids, but it could be someone that you wanted to give a role to. And they're good, I joke about, but literally a party planner. They're going to be good at bringing everybody together. They may be the most neutral family member that everybody loves. And you're like, I don't want them to raise the kids, but you know what? They'll bring everybody together. They'll make everybody feel welcome. Yeah. And so that's always going to be your spouse if you're married first. This is where you can have your kids involved that are maybe in their 20s, 30s, or even that age. Even though they may not be getting all the money initially, which we'll come to, they can still be the executor and help plan those sorts of things. But that's the executor, personal representative.
Yeah. So now one thing about them is they really have no authority. So the executor really has no authority to do anything. Their name's on some documents so they can, help at the funeral, and a funeral director will talk to them, or they can throw some weight around, but really at the end of the day, the trust is going to dictate everything. So who's going to get what, and even when you're going to the house and sorting out things, like the trustee is really going to be in control at the end of the day. So but they do they get a title and they get a role, and like Mark said, I think like the funeral and those kind of things right following your passing are probably where they're going to fill in most.
Yeah. Now, some of you may be thinking right now going, oh my gosh, I did not take that perspective when I did my trust, or maybe you did your estate plan with us in the last year or 2 years or 3 years or 4 years. And these topics didn't come up and you're like, oh my gosh, I need to amend it. Easy schmeezy. It's a revocable living trust. We can change that. We can do what's called a will codicil and modify the will and dial that in. And it's very common to see changes as life evolves. Good kids have problems, bad kids get better, marriages, family members die, all those sorts of things. Now, last guardian I'll mention, and then we'll get into some maybe unique provisions, is pets. I was telling Matt, I dove deep on this in the last week. It's kind of interesting. It's over 64%, 65%. With COVID, it was a big bump in pet ownership. But 65% of Americans have a household pet. Basically, the categories were essentially a cat or dog. Tarantulas and snakes didn't count. But interestingly, in their surveys, 95% of those people said the pet qualified as a family member, like they held them in esteem as if they were a child or a parent. And people, but every year, thousands and thousands of pets are taken to the shelter when an owner dies because the family doesn't want them. There was no structural mechanism to take care of the pet. And so this has got to be addressed. So Matt, your thoughts on that?
I mean, it's common. People want to know who's going to take care of the dog or the cat or whatever the pet may be. And it's something you can easily add to your estate plan and say, here's who I want to care for my pet upon my passing. Here's what I'm going to give them. Usually you want to give them some money, and it could be one-time thing, or it could be a payout over time that the trustee could control. And so, but you're going to leave your pet behind. You don't want them going to the pound, or you don't want. And sometimes, on the other hand, sometimes kids are fighting over the pet, or other family members are like, so now there's an argument about who gets the pet, rather than you settling the score and just saying who's going to get them and take care of them.
Yeah, I will. And I have a few stories and jokes I tell when I'm doing a workshop on this, and we don't have time for it today, but little Fido might meet you at the pearly gates if you're not careful. So you want to have a plan. And I don't like giving the guardian a lump sum of money, because I'm sorry, some of this may be a little morbid or sad view of life, but if you give them $5,000 up front, take care of my pet, and they walk off into the sunset and they're like, who's to know the quality of care? And is that pet not going to end up running around on the street the next day after they get their $5,000? So I've literally crafted provisions that say, I'm not kidding. I've crafted many times that the trustee is to distribute $1,000 or $5,000 a year for every year the pet lives. And then upon the passing of the pet, any money set aside for the pet goes to a charity or a local shelter. Again, if you leave whatever's left in the trust to the guardian of the pet, that pet may have a shorter lifespan than you imagined as well. So you got to think, okay, my pet's going to live 10 more years. I want to give him $5,000 a year. I'm going to set aside $50,000. And some of you go, I don't have $50,000. Really? How much life insurance do you have? How much IRA money? How much 401k money? How much equity in your house? Oh, you're just going to give that all to your family? I thought the pet was family. You can't set aside $40,000, $50,000 for the pet to get taken care of? Oh, yeah. Okay. So you don't have to be rich to do this. Just carve out a little money. Money talks. So
on the other hand,
okay.
California, this is one, little reasonableness here. There's, again, different ways to do this.
What? You're saying reasonable?
$50,000 for the pet, monthly payments and everything. I'm like, okay.
Annual. I said annual.
Me, Matt Sorensen, attorney, is going to be like, here's your trustee going to love this. They're cutting checks for the pet every month. Can't they just give a lump sum? And couldn't you pick someone that you actually just trusted and said, hey, I trust you with the pet. Here's a lump sum of money.
Famous last word.
What
would you do with Duffy? What are you going to do with Duffy?
Duffy's going to fend for herself. Yeah.
Oh, gosh. Obviously not in that 95% category. Okay.
Yeah. I think you pick who would get them, give them a little bit of money. I would, this is my thing. I wouldn't really necessarily they need monthly payments and everything for this. Geez. Oh. But you could be like Leona Helmsley. She gave millions to her. She'd passed away and gave her whole estate to her pet. It was like $100 million or $1 billion. I can't even remember. It was an insane amount of money. No kid got anything. Nobody. The pet got everything. So, there's different spectrums on this, of course.
Okay, which brings us from pets to kids, and let's transition straight to teenagers, because you're going to have to sweeten the pot for that teenager too. You think that guardian's going to love 3 teenagers getting dropped off on their doorstep? You got to cuff up some cash for that. So I think making sure you have some stipends for the guardian is very, very reasonable. And I'm not saying it has to be monthly. It could be annually. Don't make it burdensome for your trustee or your guardian where they have to be begging for cash. You want to be generous. But let's start rattling off some of our favorite provisions. Let's do that. I'm going to take one. You name one. How about that?
Okay.
Probably
Let
one
me,
of the most, what? No, you don't like that?
I'll go. Yeah, I'm ready.
Okay, you're ready. Okay.
All right.
I'm probably one of the ones I'm most famous for and that I've loved is giving money to kids in stages. They get a third of their inheritance when they're 25, a third when they're 30, and a third when they're 35. They're going to blow the first third. They're going to try to invest the second third and fail. And by the time they get the third third at age 35, they should have their crap together. Now, some of you are like, oh, my 16-year-old, she's so smart. Oh, my 18-year-old, he's such a great conservative kid. Yeah, you plop $1 million in their hands at age 18. I'll tell you, yeah, well, we'll see how well that goes. So I like money to kids in stages. That's my first one. What's yours?
Yeah, I love that too. And I think it helps carry on, like, make sure kids kind of work for it still too. They don't get a big lump sum. They have something to look forward to and some comfort in that too. One thing that's going to be in your estate plan, and this is generally everyone wants this, is if you have kids with a drug or alcohol addiction, the trust isn't going to pay the funds out. And this is a nice thing of a trust in contrast to a will, is the trust is going to protect that money and say, hey, all right, if we have kids or an heir that has one of these issues, they're not getting anything paid out that they'd otherwise be entitled to, whether it was the 1/3 or you're just doing a lump sum. And so that could be drug or alcohol addiction, creditors that would just dive in and take that money from them anyways. So generally your trust, you're going to have these provisions in there. We want those typically in there. You don't have to, but most people will add those in there as standard ones.
Okay. So you, if I dissect that properly, took two. One, drug and alcohol was one, and creditors was number two.
Okay. Yeah.
Okay.
But I did it very efficiently and quickly.
And deceptively. Now, I will say that sometimes we call those spendthrift provisions. If children have creditors after them, a spendthrift provision says we're not going to give them money if someone else is just going to take it. So I just wanted to throw that out. Great comments, Matt. Another one I like is if they go to college, they get money for maybe books, tuition, room, boarding, food, transportation, whatever. You get to define it. Sometimes you want to create more of a carrot than just throwing money at them to go to college. They can get more money if they get a certain GPA. They can maybe get a reward upon graduation. You may say, I'm going to cover graduate school, but only tuition at graduate school. So you're slowly creating some independence. But anyway, I would say an education provision.
Okay. Like it. All right. Okay. I like the starting a new business provision.
Okay.
Because every kid doesn't need to go to college. Some
Right.
or some of them already have.
Yeah.
So how about money to start a new business?
Ooh, like it.
And you can define a cap, the amount, to what it would be. Maybe it's 50 grand, it's not, $500,000 to start a business. You're going to be like Donald Trump, you get like a $10 million to start your business, So let's pick what you're, be specific on an amount too. So there's not an unlimited cap.
When I've drafted that, and I think we have it in our template, is that upon the submission of a bona fide business plan to the trustee. So they submit.
It's not like I'm just like, I'm starting Cray America Industries. I've already got my first intern and
fill up this ball of oil. We're going to drop it out the window here.
Yeah.
All right. Okay. The next one, I would say medical. I'd like to make sure there's a provision in there that if the child needs anything for medical in any way, shape, or form, cover it. Health insurance, deductibles, special surgeries, whatever, the physical therapy, who knows what your kids could encounter, heaven forbid.
Yeah.
But have a provision for medical on top of any other distributions that might be there.
Yep.
Okay. Got another.
All right. Okay. Let's see.
I've got one. If your kid's still married to that other bozo, you get nothing.
Yeah, that one doesn't work though. That doesn't work.
That's true. In fact, Matt, explain why. I brought that up in jest, but I wanted you to explain.
Yeah. Yeah, there are certain provisions that are like, if it's against public policy, that's not enforceable actually. And so the trustee would not be required to follow through on it. In fact, the beneficiary could argue against it and make sure they get paid out. So like you only get your inheritance if you divorce so-and-so is against public policy, because public policy is to encourage marriage and not force people to get divorced to get paid for it. So there's kind of like, there's some law in that in a lot of states. So if it's going to encourage something that would be against public policy or against the law, it can sometimes not be enforceable.
Okay. Which brings us to disinheritance. Some of you do have estranged children, and you have to specifically say, I leave this child $1,000 or zero or whatever, but it needs to be specifically stated. You can't just say, I'm leaving money to these 3 kids, and mysteriously the 4th kid's not mentioned. You're going to lose.
Yeah. So if you want to leave a kid out, you got to say that. You can't expect, well, I've got 3 kids and I'm just going to say the 2 that I like get it 50-50. Now you got to specifically say the one that I don't like gets nothing. You have to say that. Otherwise the courts kind of presume that you forgot them. And if you didn't specifically disinherit them, it could cause problems. So if you have kids in particular, and it's only kids, it's not like nieces and nephews or cousins, or you don't have to do that, but kids, you specifically have to list out and say, I'm disinheriting them. They are not getting anything.
Okay. Another provision. I like to think about weddings. You may want to say, upon any of my children getting married, they get $50,000. They could use that in any way they want, for the wedding itself, a honeymoon, buy a new washer and dryer, buy a new home together, whatever. But upon marriage, and I've had clients be very clear, upon their first marriage, before age whatever, or after age whatever, because they don't want kids to run out and get married at 19 just to get 50 grand. So you can, again, get really creative. This is really the narcissist way to control their family from the grave. I mean, really, if you haven't jacked up your kids enough now, do it while you're dead. Put in some fun provisions.
That's a great spin on that. Okay, let's hit. I'm kind of take a little bit of a detour. We're still on the same path here, but just maybe a scenic route here. What about other weird certain property you have? I think we got to talk about that. Sometimes it's like, well, I own a boat with my sister. And it's like, when I pass, I just want my sister to get the boat. We kind of bought it together, and my family uses it, her family uses it. And so think of things you may have together. Maybe you have a business partner some assets might pass separately with a business partner. So sometimes just think of some specific property or assets that are tied to another person directly. And we usually like to address this in your estate plan in a separate section. Before we get to everything else, we kind of just say, is there any specific property we got to have a special plan for? Let's state that now and who gets it. And then everything else, we're throwing all these conditions on.
Yeah. This is oftentimes referred to in the business continuation plan topic. You may have a section that says, here's who gets my business. In the family farm situation, which it can really be, I'll say, quite an emotionally charged situation. There's a old school farmer mentality that I think is carried over for the last couple hundred years, that the oldest son gets the farm. And I've been in those meetings where the daughters are like, well, what the heck? Oldest son gets the farm, the truck, all this, he runs off into the sunset. What did we get? And in those meetings, I've tried to really encourage mom and dad to focus on the value of the home, maybe a little life insurance, and say, you know what, can we do something for the rest of the kids? And there's some real old school mentality there that sometimes is an uphill battle. So just unique.
Yep.
Okay. I was going to say also, buying a first home. You could say, I want to leave money for all my children. This could be grandchildren. This is another exciting one that you can say, oh, I've got enough that I want to leave a little bit to each grandchild to buy their first home or to go to college or whatever. So I'm going to bring it in the grandchild conversation. But
I like that one. The grandkids, to throw in something in for them, for, like you said, education, buying a first home even. Okay, because I kind of got on that little specific property and kind of on that detour, just throwing this out there.
You stay on that off ramp, man. It's all right.
Is sometimes you got other little personal property assets. And a lot of times we're going to do a personal property memorandum where you can just say, hey, the jewelry is going to go to this kid. The musical instruments are going to that kid. these guns are going to this one, these ones are going to that one. Where you can be a little more specific about specific items of property that are personal property that have some value to you and some of your loved ones. So a lot of times you can outline that in your memorandum of personal property that's done when you sign the estate plan. You can add to it whenever the heck you want. If it's something significant, we can throw it in the estate plan just to be right in there. But just think of some of that personal property that you might want to decide who gets what. But again, this is where I want to say, do not get hung up on this. A lot of people just don't do an estate plan because they get hung up on this. Well, I got all this jewelry. Who's going to get this one? I got to go get an inventory of that. If you don't know in your head who's going to get it, you can't think it through, don't worry about it. Just get that all out. Worry about everything else later. And you can add to that later.
Yeah, I like it. In fact, maybe this is a good point to bring this around to some sort of conclusion on this issue. We have a questionnaire that we ask all of our clients to fill out when they're starting their estate plan. We have an estate planning special this month. Every year, we try to really kind of drill down for a month in June on estate planning. You're going to see it in our newsletter right now, a number of articles on this. We got more to write. So we're going to kind of deluge you for a month on this topic, because I think, again, so many people procrastinate. We want you to feel educated, empowered, and not afraid or miserable to take care of this. So I was going to say, in this questionnaire, we have a whole list of ideas. You know, the kids get $1 for every dollar they earn. They get money for this. You might have some money going to charity, and the list goes on and on. So when you meet with the attorney, you'll flesh out these issues. What I recommend to all of you, if you've gotten some ideas from this podcast now, is pull out a yellow pad, pull out some notes on your phone or whatever the app, and just start thinking, you know what, here's what I want. You get to write the law. You just spit out anything that comes to mind. Our job is to put it in legalese, make sure it's non-contestable, and it's done. And then you can change it again and later if you need to.
Yeah. Okay. Can I hit two other ones you got to think of?
Yeah, sure.
So let's talk about your powers of attorney.
Okay.
Because you got to make some decisions on there, and you're going to have two separate ones. The first one, let's get that one off the table because that one's easy. The power of attorney for finances. If you got a spouse, this is your spouse, and generally, and then upon your passing and your spouse's, it's going to be your successor trustee. You generally want who's going to have power of attorney for finances. It's kind of usually the same person. It's not always, but a lot of times that person, you've already entrusted them with your trust. They should know a little bit about your stuff before you're passing. So a lot of times I like it to be that same person. Now, the healthcare power of attorney is different. This is someone who might be a little bit better with healthcare. Maybe you've got someone with healthcare background in your family, one of your kids or other family members that could help for this. And remember, this healthcare power of attorney, these power of attorneys are for while you're living. It's about, like, you know, if I'm in a state where I can't make medical decisions for myself, who do I want to make those decisions? Again, they typically be your spouse. If your spouse has passed, you don't have one. Who's someone that could make good healthcare decisions? Maybe they're in that profession as an employee or healthcare professional. So just that's going to come up in your decision making too. You want one of those.
Yeah, and when it comes to estate planning, remember, an estate plan is a big old binder. I really ought to grab one over here off the shelf. I've got one across the room here. But in that binder are these powers of attorney, the will. You're still going to have a will that's going to tie everything together with your trust. You'll have also the living will, or the healthcare directive that says, if I'm a
pull the plug.
Yeah. The person that you've appointed as your healthcare power of attorney, they're not in charge of pulling the plug. You are. And you're saying that in advance. You're saying, if I'm a vegetable, just pull the plug. And if there's no one around to pull the plug, my ex will do it. And they'll rush right over it. They really will. They'll help you out. They shouldn't have a problem with that. And usually they'll do kind of that cord wrapping mechanism, procedure where it's
tidy it all up.
Yeah, it's not going to go over and just pull the plug. They're going to stand about 10 feet back, wrap the cord up in their hands, and then really give it a good yank. Really get that out, It's therapeutic. So you can appoint that in your healthcare directive. Just get it taken care of. Yeah.
That part's optional, of course. Now, you're also, a lot of times you're going to say, do you want to donate your organs or not? That'll a lot of times be in that, so you can make a decision there. And it's interesting, the people who, I just see clients over the years, some people are like, hell no. A lot of people are like, yes, what the heck? They're not good to me. So, but that's for you to decide, throw that in there.
Yeah, it's been fascinating how many people have stopped by and asked Matt, could you donate your body to science? And Matt, that's been a big issue for you. I mean, it's really,
I know. I mean,
quite the specimen.
Medical profession wants to study it, How can we replicate this?
How can we replicate that? This unicorn, how do we get that? Oh my gosh. Well,
far from.
Yes. Now, when you go out shopping for your estate plan, I know some of you want to go meet face to face with a local attorney, or you've got your good old family attorney from years past, and you may even get schmoozed by a big law firm. I think budget wise, you should all plan for somewhere between $1,000 to $2,000, somewhere in that range. We charge $1,500. We're doing a special every year around this time where we knock off a couple $100. And I had a financial advisor yesterday say $1,300 for the trust, will, the whole 9 yards in a binder, and I get to meet with an attorney. $1,300, that's too cheap. I'm like, no, that's, I think, fair. And we make a lot of other attorneys upset that charge $4,000, $5,000, $6,000 for the same thing we're doing. Maybe there's a lot better advice and maybe a few extra bells and whistles, and they spray the paper with, some
gold leaf, they got gold leaf paper.
Gold leaf, that's it. Yeah. So, but at the same, and I know for some of you, $1,300 to $1,500 is expensive, and I get that. We're trying to find a happy medium. You're not meeting with the attorney for hours on end. Some of the estate planning attorneys will do that. They're going to have a lot of meetings with you and vet things, and that's fine. If you want more time with us, it's going to cost more, but we've tried to create a good balance. And so when you go out and shop around, keep those prices in mind, because we don't want you to get taken advantage of. Now, trying to get an entire estate plan done for $500, holy crap. I mean, I don't see it. And if you try to do it online, you'll jack it up. This is something that you want to keep around the rest of your life for the next 20 years and amend it from time to time. Try to at least be in that $1,500 range and do a good job.
Yeah, I know a number of lawyers who make a living, and literally this is all they do, literally make a living on fixing do-it-yourself estate plans. That's all they do. They target those people that did them. I don't know how they find them, but they just target them. And most people are like, yeah, I have no idea what I did, and if this is even legit or not. But plan it right. Just get some advice from somebody who's drafted some estate plans before. Doing yours is going to be your first one. What's the first thing you ever made? The first time you freaking cooked an egg, you probably sucked at it. Don't do this to yourself and do your first estate plan making your own. All right. Yeah. But someone who's done them before, we got the process down. We got the docs that work in all 50 states. We can help advise you and walk you through it. But it doesn't have to be rocket science either. We're trying to find the happy medium of let's get a good estate plan done. Let's think through the issues, tailor it to you, get it done, but don't overthink it on the other hand. Okay.
Yeah.
Some clients want to talk about this for like 10, 20 hours. That's not the $1,500 estate plan either. Yeah. Okay. Just get in, make your decisions. Because what happens is, and if you don't realize this, you already have an estate plan. If you don't have one that you made, you have one the government made for you. Your state government already decided what's happening to your state if you didn't do anything. Yeah. And let me tell you, a lot of times that is not what you want. Your family's going to end up in court. A judge is going to have to decide. I guarantee you they're going to have family members disputing on what it was you really wanted and what you said. And so get the plan done. Save your family the heartache. Create a legacy. Get the stuff you want done. It's like win, win, win. But I know it's just one of those things that people hit roadblocks. So get it done.
Yep.
I don't know.
I love it.
Get her done.
Okay, now here's a precursor for next week's episode. Part 3 is what do you do once you sign this darn thing? And we're going to talk about funding it, maintaining it. Is it really that much of a headache? Is it expensive? And I'll give you the short answer. Spoiler alert. No, there's no tax return due every year. There's no bookkeeping, no new bank account required. It'll spring into effect in a variety of ways. But there are certain assets we want in the trust, and we're going to talk about all of that and more next week in part 3. So yeah. Thank you, everybody.
Right. Yeah. Thanks, everyone. We'll see you back here for part 3 of the estate planning series on the Main Street Business Podcast. Remember the special, get to kkoslawyers.com. Save $200 on our already awesome estate plan pricing. Don't miss this. kkoslawyers.com.
Wow. You could do commercials.
Yeah.